session with Dr. Forster. And to introduce our next speaker, I'd like to bring Barbara Gale from Georgia back up. Barbara?
I feel so honored to be able to introduce Nancy. As a lawyer, we are always so impressed by lawyers who are able to do just really wonderful things, and she has. Nancy has argued hundreds of cases in the Maryland Court of Special Appeals and the Maryland Court of Appeals over the last 30 years, and she has argued in the United States Court of Appeals for the Fourth Circuit, as well as the United States Supreme Court. She's been nominated for a judgeship on the Maryland State Court of Special Appeals in 2002 and the Maryland Court of Appeals in 2003. So that kind of a nomination indicates that her peers think that she is one smart lady. She began her legal career in the Office of the Public Defender's Appellate Division and was named the Public Defender for the state of Maryland in 2004. And she continues to teach as an adjunct professor of law at the University of Baltimore. We talked about Baltimore and Baltimore. And she frequently teaches CLE, or continuing legal education classes, for attorneys and judges on various aspects of criminal law and procedure. And few lawyers have argued more times than Ms. Forster before Maryland's highest court on criminal law issues. She is here today to talk to us about the recent challenge that she did have in Maryland and a class action that she filed a couple of weeks ago. And I'm sure all of you are going to be so interested in hearing her successes with the challenges to the ex post facto application of the SORNA, which drives us all crazy. Mm-hmm. And I give you Miss Nancy Forster.
Well, that was very nice. Thank you. I appreciate that. So yes, I'm Nancy Forster from Baltimore, as we say back home, but I try not to. I'm from Baltimore. So what I wanted to talk about this afternoon is the challenges that we brought in Maryland to the sex offender registry laws. The sex offender registry laws in Maryland went into effect on October 1, 1995. And at that time, it was very limited. There was annual reporting for a period of 10 years. And there was only one category of offender known as a child sex offender. And the crimes for which one had to be convicted of in order to fall into that category were very few. So not many folks were made to register in the state of Maryland in 1995 when it first began. As the years passed, however, and I was speaking to someone earlier, I forget who, because I've talked to a lot of wonderful folks here. Every single year, if some horrifying crime occurred that year, boom, the legislature fixed the law to make it even worse for those on the registry. And that knee-jerk reaction seemed to happen at least every 2 years. So there were continuous changes to the registry laws. 1995 to 1997 was a huge change. 98 was. 99, the big one was in 2001. And the reason that was the big one is because that was the year that the legislature made the laws retroactive. From 1995 until 2001, the legislature had always made the law prospective only. And as I had said earlier in one of the other seminars, is that in Maryland, what happens when the legislature wants to pass a law, if they're uncertain of its constitutionality, they will ask the Attorney General's office for an opinion. And in each of those up before 2001, the Attorney General said that it was, if you make it prospective only, you're okay. Because otherwise it may violate the ex post facto laws. So that's why it wasn't until 2001 that the laws were never retroactive. It changed in 2001 because of the Supreme Court decision in Smith v. Doe, I think there's so many Doe cases, I can't keep them straight anymore, where the court said it's not punishment. Okay, so once that happened, Maryland law sort of took off with making everything retroactive, adding even more restrictions, more categories or classifications of offenders. They added, not only now were there child sex offenders, there were offenders, and there was a sexually violent offender category and a sexual predator category. So they added 3 categories. They added a whole slew of laws for which, or crimes that if you were convicted of, you fell into one of these categories. And they increased the time on the registry. Now it's not just annually reporting, but if you are, for instance, a sexually violent offender, you have to report at that time every 6 months up to life. And so they were constantly expanding the law. In 2009 and 10 is when Maryland adopted the tier system that exists in the federal level, Tier 1, 2, and 3. Tier 1 being, at this point, 15-year registry, and Tier 2, 25, Tier 3 is life. And they also, Maryland started switching the different kinds of convictions, the majority of which now today require Tier 3 lifetime registration. In fact, I think it's about, and Brenda Jones knows better than I on this, but it's almost 85% of the registrants in the state of Maryland are Tier 3, which tells you something because, you know, come on. Not that many folks are dangerous and belong as lifetime registrants. But that's where the legislature, you know, has just sort of glommed onto this whole fear-mongering, and that's why they continually change the law. So what happened is, and I explained this, so I'm going to be a little bit repetitive, but not for long. In 2009, a friend contacted me, who's another attorney, about her son, who was in college in Minnesota at the time, who had what he thought was consensual sex with a girl, another college student, so she wasn't a minor. And they were drunk. They were both drunk. You know, they wake up the next morning and she's, oh my God, what happened here? And he wakes up and he's like, okay, can I have your number? So she goes to the police, and you know the rest is sort of history. He gets an attorney. His mom goes running up there because she's a prominent Maryland attorney. And he winds up pleading guilty, not to rape, but to some lesser offense that does not require him to register in the state of Minnesota where he was. Now, he wants to move back to Maryland. He gets kicked out of college, of course. He can't return. So he moves back to Maryland where his mom is, and Maryland says, well, your offense is considered here a Tier 3 lifetime registry offense. You have to register. So not only is he no longer able to attend college, but now he's going to have to register. Well, his mom goes into, overload, and she's looking for an attorney that does a lot of criminal work. So she calls me. And so she gave me the whole story, and I said, what is a registry? What is this thing? I was like, I've never heard of any such thing. And she said, well, you look it up and see if there's anything that can be done for my son. So the first thing we did is I talked to the attorney, the attorney general, the assistant attorney general for the Department of Public Safety, which is the agency that makes folks or monitors your registration. And I said to him, look, he's a friend. So I said, look, can I call in a chick, and can you please don't put this kid on the registry yet? I said, give me time to look into it. I don't know anything about it, but can you just do me that favor until I can figure out legally if there's anything that can be done at all. I have no idea. He said, all right, fine, we'll make sure that he doesn't register until he gave me like a couple months. So I started doing a lot of research. And I was shocked, as I said earlier, as to what was actually on the books. And so I devised this argument that in Maryland, and I think this is true in all states, is that if you're convicted of a crime in one state and you move to another, what that state that you move to does is looks for the equivalent crime in that state to tell you whether or not you'd have to register. And so I came up with this really wild argument that what he had been convicted of in the state or pled guilty to was some kind of sex offense that was defined as touching for sexual gratification, even if it's touching over clothing. And Maryland has nothing like that. Maryland has a touching, but it's, it doesn't say over clothing or blankets, which is what the other thing was, even over a blanket, which, geez, that's kind of crazy. But anyway, you could, yeah, I don't even know what to say. So I came up with this argument saying there is no Maryland equivalent law. And so you can't say he's been convicted of anything equivalent to Maryland. And not only that, let me tell you this. I looked at the Maryland Constitution and I said, do you know, and most people did not even know this, in Maryland, our ex-Constitution, Article 17, says, just like the federal constitutional provision, which says the legislature shall pass no, or in the federal concept, Congress, shall pass no ex post facto law. Well, Maryland has a second clause separated by a semicolon that says, nor shall the legislature pass any retrospective restrictions. Ooh, I was like, ooh, I'm getting this one, So I added that. I was like, not only is there no Maryland equivalent crime, I said, but even if we say that it is, there is an equivalent to what they were calling a fourth-degree sex offense. I said, this is an ex post facto issue here, constitutional issue. And I said, and I'm not talking about federal ex post facto. I said, I'm talking about the two clauses under the Maryland Constitution. It's ex post facto law, and it's a retrospective restriction. I said to the Attorney General, I said, you tell me where in that Maryland sex offender registry law there is no restriction. And of course, he was looking at me like, yeah, well, I guess I really can't. And so I went to the attorney who, by the way, never paid me a dime for this. This is friendship, right? So I said to her, I said, look, here's your argument. And I drew it up and I gave it to her. And I said, and what you got to do is you got to file a declaratory judgment action. I said, you're going to do it yourself. I wrote it all up. That's the least you can do since you're not paying me. And so she filed it. And the Attorney General, the Assistant Attorney General, came back to her and said, we're not going to make him register. Okay? They didn't want to go into court on that ex post facto restriction issue because they knew they had an uphill battle on that. So that's all I needed to hear, okay? So I happened to be sitting, I have a case totally unrelated to ex post or sex offender registry in the Court of Special Appeals of Maryland, which is the very first level of appeal. Our highest appellate court in Maryland is called the Court of Appeals. It's only we in New York have that. Every other state calls their highest court the Supreme Court of that state. So I'm sitting in the Court of Special Appeals on a totally unrelated case. And this woman, who I also happen to know, but not real well, is arguing, and I know she's not an appellate lawyer. And I'm not a trial lawyer. I've done trials. I hate it. I'm an appellate lawyer. And so I really don't like doing trials. Trial lawyers should not do appeals either, okay? because it's a completely different animal. It really is. So she's up there, and I can hear her voice quivering like this, you know, because you're arguing before 3 judges at this level, not the 7 at the highest. And she's just not doing a good job. And what is she arguing is Doe versus the Department of Public Safety and Correctional Services, which is, this client is Mr. Doe, committed an offense before the 1995, before the law even existed, the registry even existed in the state of Maryland. She has it on appeal, and she's trying to make a constitutional argument, but she's just not getting it right. And I'm sitting in the back, and I'm thinking, oh my God, this is it. This is the case. I want this case. And I knew she was going to lose in the Court of Special Appeals. We always lose in the Court of Special Appeals if you're representing defendants anyway, but she wasn't doing a good job, and she knew it. So after she finishes arguing, and I see the court's not going her way, I follow her out into the hallway, and I said to her, I said, Pat, listen. She said, oh, I'm so sorry, Nancy, that was awful. And I said, you know, you did the best you could. I said, but, you know, you're not going to win, and you know you're not going to win. She said, yeah, I know, I can tell. She said, but I'm just not comfortable in the appellate courts. And I said, nor should you be. You're not an appellate lawyer. And I said, I'll tell you what, when the opinion comes out, it will be reported, which means the court at that level can decide whether or not to publish an opinion. And if it's published or reported, it's precedent. It has precedential value. If it's not reported, it has no precedential value. Now, I said to her, this case is going to be reported because it is such a novel issue. And I said, when it comes out and you're going to lose, I said, can I have it to take it to the highest court? And she said, why? My client doesn't have any more money, barely have money for this. I said, I don't care. So I'll take it pro bono, give it to me. Ask your client, is he willing to let me have it? Sure enough, the opinion comes out, it's reported she loses on the ex post facto issue. So she calls me and she's like, oh my God, Nancy, will you take it? And I said, well, will he let me? It's up to your client, it's not up to me. And he said, sure, go ahead. All right, so that's how I wind up in Maryland's highest court with the Doe case. Because what the Court of Special Appeals said was just, it doesn't even matter, it was utter nonsense. It was just essentially, they pointed to the federal law, the Supreme Court case, Doe v. Smith, saying it's not punishment, therefore who cares what happens to these people. So I wrote when you go to Maryland's highest court, it's not automatic. You don't just file the appeal and they have to hear it. You have to write a petition requesting that court to hear the case. And they can say, no, we're not going to hear it. And that court, what they're looking for, because every opinion they write is published, is obviously of critical importance. So they're not going to take cases that don't matter to anybody. They're looking for novel issues, things that have never been brought up before or challenges that have never been made before that they want to be the last word on, okay? And this clearly was one of those cases. So I wrote the cert petition, is what it's called. I wrote the petition, and there's a real art to writing the question presented in these cases, okay? You got to make it sexy. You really do. That's what we appellate lawyers say. You got to make, it's kind of ironic, isn't it? You got to make the question sexy so it grabs the court, and they're like, oh man, we have to take this case. So that's what I did. I wrote it in such a way as to say not only does it violate the ex post facto clause of the Maryland Constitution, but it sure is retrospective restrictions. And, you know, so I did that in the first question and had all these other questions that I knew I couldn't possibly win, which is the due process, lots of ways that it's been challenged unsuccessfully all over the country. But I really didn't care about those. I just wanted that first issue up there. And I didn't rely at all on the federal constitutional question, because once you give the court a chance to rule on that ground, they can ignore the other grounds. They say, we don't need to address the Maryland Constitution because we're addressing it at the federal level. So I didn't even put that in there. That wasn't even raised as a possibility to lose. Okay, so the court takes it, which pretty much was guaranteed because it was such an interesting case. All right, so then I go and I argue before those 7 judges in this case. And I'm pushing the restrictions section because I know that the state can't possibly win. There's just no way you can say these aren't restrictions. So I say if it's not punishment under the ex post facto, at the very least it sure is restrictions, and you're retroactively applying them. And I could tell from the questions the court was asking me, they did not want to go there. Because think about how that would undo not only the sex offender registry laws, but lots of laws that require restrictions on folks. So, and I did all this history. I was like really impressed with myself. I did so much historical research on the Article 17, where the restrictions came. We went all the way back to the Civil War and what it was really all about in the state of Maryland, who was fighting who. And what it really came down to is it was a way to keep a certain segment of the population in Maryland from voting, because they would put restrictions on folks to keep them from voting. And that's really what it was all about. But the language they used was so broad, you could apply it to anything, is in my humble opinion. So I'm up there and I'm arguing this, and I see they don't want to buy that, but they want to buy something because they don't think this is fair. And finally, so I'm saying to them, there's no way you can say this is not punishment. And I go through the internet, posting. One by one, I'm going through all these restrictions and on people's lives, on the lives of their families, everything, all the typical arguments you can make. And so this was back in 2013. So in March, I think it is, of 2013, they issued the decision. And they rule in my favor on the ex post facto. They say, we're not even going to talk about that restriction clause. We don't need to. We don't need to. We're going to just say this violates the ex post facto portion of the Maryland Constitution. Now, the state wanted them to deal with the federal Constitution. They refused. Because, and thank God they did, because the reason they did that is because the majority that wanted to go my way in the case, because I didn't get all 7, they wanted to insulate the case from going up to the U.S. Supreme Court. The way you insulate a case from going up to the U.S. Supreme Court is don't address a federal question, okay? If it addresses a federal question, the U.S. Supreme Court can take the case. So the Court of Appeals bought my limitation to the Maryland Constitution and said we will not address the federal argument that the state was trying to make, which meant, boom, the Supreme Court can't review this case, thank God. Okay? So what I got in that case is 2 judges, all right, so we got 7. I had the chief judge she dissented vehemently. She thinks it's not punishment, she said. She and one other judge. And then I had 3 who said outright, I'm absolutely right, it's punishment, there's no way you can say it's not. And then there were these 2 judges who said, we believe that it has crossed the line into punishment, but we would review it under the federal Constitution. Okay? So here I've got a huge split. This is what's called a plurality opinion, where I don't have 4 saying absolutely, I go your way. I have 5 going my way for different reasons. So what you do, or the law is in that situation, is you go to the narrowest holding of a majority of the judges, and that's the law. And what I could glean from at least 5 of those judges agreed it's punishment. And that's all I really needed, was to get them to say it's punishment. So the narrowest holding is that the law in Maryland, the sex offender registry laws, constitute punishment, and therefore making them apply retroactively violates the Maryland Constitution. Okay, so yay, we win, okay? Yay. Hold your applause. It's never that easy, really, seriously. So I'm all excited. Now what happens is when you win at the appellate level, what they do is they send it back down to the trial court where it all began to say you have to enter this order, that this person must be removed from the registry because it's unconstitutional. So I jump the gun and I write up an order to assist the court. And I make the order say you will remove him from all registries, okay? Federal, and we listed all of them with the help of FAIR. They told me all these registries that I, again, was ignorant of, and tell them, you put them all in the order. We go back down to the circuit court, and I present the order. The judge signs the order, he agrees. Now the state files what's called a motion for appropriate relief. They said, circuit court judge, you don't have the authority to tell the department to remove him from anything other than the Maryland registry. And because of the Adam Walsh Act, he has to register at the federal level. Okay, so we're not removing him from the federal registry. Show of hands, anybody seen the federal registry? There's no such thing, okay? There is no such thing as a federal registry. What it is if you put in Google in federal sex offender registry, it'll come up what state. And you say, all right, Maryland. It shoots you right down to the Maryland registry, okay? So, and it does that for each state. There is no one omnipresent federal registry, okay? All right, so the state files that motion. The court denies the motion for appropriate relief. And so the order is still in effect, take him off of everything. Of course, the state appeals. We go back up to Court of Special Appeals, the intermediate court. And that court's like, whoa, we're not touching this because we know it's ultimately going to go up to the highest court here. Certifies it up to the Court of Appeals, the highest court, which I'm glad because it was a recognition that it would have been a waste of everybody's time because it's going to wind up at the highest level anyway. So we go up to, again, the Court of Appeals. The state is arguing there's a federal requirement that Mr. Doe register. So even though he can't be made to register under Maryland law, he can be made to register under federal law. And because he's in Maryland, it's our registry, therefore we keep him on there and we're not going to take him off. So again, I mean, ad nauseum with the research I did, and I had the Commerce Clause, I was arguing, I don't even know half of the constitutional arguments I was making, but I was throwing everything in the kitchen sink in there. But most importantly I was saying, hey, you're the court that said take him off. Are you now going to let the state stand here and tell you can't do this? And no matter what you say, we're keeping him on. So the court didn't like that very much, as you can imagine. And so not long after it was argued, they came out again, this time 7-zip. 7-zip says, no, we don't care what the federal law says. What we care about is if you're in the state of Maryland and this, the Doe decision applies to you, then you cannot be made to register in the state of Maryland. And we don't care about Adam Walsh, okay? That was pretty bold for them to do, obviously. And they said, I wrote it down, the wording they used. It was something like, because what the state was saying is, we're not acting on behalf of the state of Maryland. We're putting our federal hat on, and we're saying, come register now because we're federal folks now. And the Court of Appeals said that the state cannot legally accept a sex offender's involuntary registration when the registration is unconstitutional under Maryland law. So in other words, the state was saying, you have to come and register with us anyway, even though you don't want to and you think you don't have to. You got to do it anyway. And the court said, no, you don't. All right? So at that point, I'm thinking, all right, man, I'm done. I'm burnt out with this stuff. I have nothing left, and I've won both times. What else can happen? You know, it's never easy. It really is never easy. So what does the state do? Now the state takes the position that, well, Doe only applied to those people who, like Doe, committed their offense before the existence of the registry. It doesn't apply to anybody else because those weren't the people that Doe was concerned about. So here we go again, another round, but I couldn't find a case that was good enough to take up on that specific issue. So what I started doing was I started to get a lot, as you can imagine, the minute each of the Doe decisions came out, people were lined up at my door. And there were several, I'm ashamed to say, attorneys in the state of Maryland that were ripping people off big time to get them off the registry. I mean, charging lots of money. And that just pissed me off. I mean, it really did. It really made me angry. Look, I'm not one of these rich lawyers. I just happen to be married to one. And so I got nothing to lose, you know? And so these people would come to me and I'd say, $500, I'll file a declaratory judgment action for you. You know, because here's the interesting thing that I noticed. Normally, I would say, I'll do it for nothing, don't worry about it, we'll do it. People want to pay. I never, ever knew this, because all my life I was a public defender and never had to take money from people until 2009 when I'm out on my own. And private attorneys would always say to me, people want to pay a lawyer to do work. If they don't pay, they think you're not going to work as hard. And I was like, but it's true. It's really true. I just don't think you should be ripped off, okay? But anyway, that's my little thing. So I'm charging them very minor amounts of money, and in every case, I must have filed, 20, 25 declaratory judgment actions all across the state of Maryland. And I'm winning every one because I'm saying there's nothing in Doe that says it's limited to anybody whose offense was before the actual institution of the registry in the state of Maryland. And now the state's getting really annoyed because not only do they have to answer every single individual complaint that's being filed, and it's honestly, I was from the Eastern Shore to Western Maryland in the mountains filing these complaints. They've got to answer every single one of them and send somebody to court to make the argument only to lose. So they took a new tact, and that was, they said to me, if you're going to do a declaratory judgment for somebody, can you let us know in advance? We'll look at it, let you know if we agree with you, and if we agree, we'll just take them off and we don't have to bother going to court. I said, sure, that works for me. That sounds good. And so we started doing that, and I would just send them the documents that they needed to make their decision. And they, true to their word, started removing people, like this, no problem. So, after a good period of time, about almost 1,200 people were removed, okay, through these two cases and these declaratory judgment actions all over the place. So then I'm thinking, Doe's got to apply to more than just the folks, who their time, the offense was committed was pre-October 1, 1995. And again, through FAIR, we sit down and we do a lot of, head banging, and we're like, well, wait a minute, why doesn't this apply to those people who, when they committed their offense, it was not one that required you to register, but when they changed the law and made it retroactive, they included that offense. And I couldn't come up with any reason why Doe shouldn't apply to them as well. It's retroactively applying the law to somebody that when they committed their offense never had to be on the registry at all. So And then the other category, I thought, well, why doesn't Doe apply to people who at the time they committed their offense had to register for 10 years? You apply retroactively the new law, and now they got to register for the rest of their lives. And then lastly, why doesn't it apply to people who at the time they were on the registry only had very minor restrictions, but now when you apply retroactively these new laws, now they've got to do everything under God's green earth to comply with the sex offender registry. So we filed a class action, okay?
Did you ever get paid?
So we filed class action. No, fair is fair, and they are paying me. They are paying me. So what we did is, or put together a class action lawsuit to cover these three subcategories, subclasses, to say there's no reason why Doe should not also apply to these. Now, think about it for a minute. What a pain in the ass that is going to be for the state. Just talk about the restriction requirements. They're going to have to go through year by year. Now, mind you, I've already done this. I know which restrictions were added each year and who they've applied them to, okay? But they don't want to have to do that, you know? They don't want to do this. And, you know, so it's a real pain to figure out who these people are and which restrictions. The other categories are easy, those people whose time was increased or whose offenses were not registrable offenses when they actually committed them. Because there really were only two, I think, that were added. It was fourth-degree sex offense. You did not have to register early on in the registry law. And then misdemeanor possession of child pornography was not a registrable offense in the state of Maryland either. So they were later added, though. So, but to figure out each of the restrictions is just going to be an absolute nightmare for the state. So where I am right now is I'm waiting for their response because it was filed 3 weeks ago, the class action. And we've sued the state of Maryland, the Attorney General, the head of the Department of Corrections. And I enjoyed this. I sued every single one of the local sheriffs that you have to report to, you know, and that was fun. And then the Department of Juvenile Services, the head of that department, is also being sued, and the Attorney General himself is being sued. So, I think I caught him off guard with this. And the reason part of it is that when they started to lose, and even though they agreed at that one point that, you know, just tell me the declaratory judgments in advance and I'll remove them, you know, out of the goodness of my heart, I filed a Freedom of Information Act request with the Department of Public Safety, and I said, I want a list of everybody on the registry and the date their offense was committed. And so with my intern and paralegal, we went on the registry for every single person, it was a lot of people, and found that there were still Doe people being made to register on there. And so I don't want to jump ahead of myself, so I'll tell you my new litigation theory that I have coming up. And I was starting to get annoyed, so I'm emailing and I'm saying, look, you know, you've lost, you agreed that you'd remove these people, you still have, and I would list 10 people that are straight up Doe. I mean, these are people whose offenses were committed before it existed, and they're still sitting on the registry, and we're 2 years past Doe, okay? Why are they on this registry? Silence. I got no answer. And so now all the nicey-nicey play is done with. And my name is in the state of Maryland and the department. They won't respond to any emails I send them. They won't respond to telephone calls, nothing. So I said, you won't respond to that, you'll respond to a lawsuit. So, you know, we'll see what happens. And I'm going through the list again, and I notice on this list the people that are actual Doe people that they are not removing happen to be folks whose convictions were in another state. That seems to be the similar theme. But I can't come up with a basis that they're relying on for not removing those people because, of course, you know better than I do that the registry applies to where you live, go to school or work. And if you're living in the state of Maryland, oh, right, which I loved in their argument in Doe, and they argued to the court out loud in oral argument, you're going to make Maryland a haven for sex offenders. Bring us your sex offenders, okay? So and people are moving to Maryland. It's pretty funny. They call me as soon as they get here, or before, and they say, hey, I got this in Delaware. If I move there, am I going to have to register? Yeah, no, come on. And they don't, and they can't make them register. It makes them crazy. So anyway, that's why they're stonewalling me now. They won't deal with me at all. So, unfortunately, but I don't care. I really don't care because I'm right. I'm right, and they're wrong, and they're just being big babies about it. As far as I'm concerned. So listen to this. So here's what I'm thinking, and we got to keep this amongst ourselves, okay? Here's what I'm thinking for my new challenges. Besides the class action is going to take, and unfortunately, that's the thing. It's going to take a long time. And that's why when folks call me and ask me, am I a part of the class? If you fall in the category, yes, you are. You will be covered once it is finally litigated and if we win. But a lot of people, understandably so, don't want to wait that long and maybe fall into those categories and shouldn't be on the registry. And they're the ones that say, I want to go ahead with a declaratory judgment and get it done right as quickly as I can. And I perfectly well understand that. But we're at the point now, because I represent this class, I can't handle these declaratory judgments anymore because it would be a conflict of interest. So I'm farming them out to other lawyers I trust that I know will not rip people off. And I write the declaratory judgment anyway and send it to the lawyer and say, file it. Would you just, sign it and file it under your own name? So here's my next thought. For that list I told you, the people out of state who are living in Maryland now, but convictions were out of state, there's such a thing as called a Writ of Mandamus. And what that means is you file a Writ of Mandamus to the court, and in my case I would file it with the highest court, the Court of Appeals. And it is you're asking for that court to mandate that the agency covered by the Doe decision, which is the Department of Public Safety or Department of Corrections, that they order them to comply with the Doe decision. So again, now we sort of come full circle when I do file it. I haven't done it yet because I'm getting all the names together again. I'm going to go to that court and I'm going to say, 2 years ago, you put out a decision saying these folks can't be made to register. And then, like in the comedies, drop the whole list of people. Say, all of these people are Doe, and they're still being made to register by the state of Maryland. Sign this mandate telling them to take these people off this registry. So that's my next thing that I'm going to be doing. I'm putting that together now. And again, it comes back to when I said full circle, saying to the court, they're thumbing their nose at you and saying, we know you said Doe, but we don't care. We've got these people, and we're just not going to remove them. And they're all Tier 3. That's the other commonality. They're out-of-state convictions, and they're all Tier 3. So that's to cover those people. And then the other way down the line action, because this will require a lot of time. I had a doctor, a medical doctor, come to me who was convicted federally. And I don't remember for what. I think it was child pornography, but whatever. And he brings this book to me, and I can't remember what it's called. It's like this big white, paperback book. And he says, "Look at this." And I said, "Well, what? Just point me to what you want me to look at. I don't have time." So he says, "This is the book that the sex offender treatment folks that I am made to go see, use in their treatment. And I read through this thing, and not that I don't trust him, but it is a book, and I haven't found anybody else that's been made to use this, so I don't know if it's just a federal thing. But it's got all kinds of really wacky ideas in it about how to make people compliant. Like there was something in there about it recommended to the offenders that anytime you have a thought, a bad thought in your head, that you start pinching yourself really, really hard. Has anybody heard about this, or am I crazy? Really? Yes. Oh my God, it's real. Holy crap. So it's real. Aversion therapy, that was it. Wow. All right. So here, and we all know, or I highly suspect, that a lot of these treatment programs are money makers. So that's my next cause of action. I don't know how yet. I don't know how I'm going to do it, but I know. I have tried that at the state level. I have not been successful in those, but this one is really wacky. I mean, this is, yeah.
I'm just wondering, are you moved to Texas anytime?
Hell no. Not until they bring back Ann Richards. Sorry. No can, no can do. No can do. Right.
People were wondering about the legal name.
The what?
Would you marry us?
Oh, yeah. Oh, but and so in Maryland, they have this thing called the COMET program. Is that just a Maryland? But it's I forget what it stands for, but it's again another sex offender treatment thing. So I go to the this training program that COMET is putting on for the judges in the state of Maryland. One of the judges on the appellate court asked me if I would come and talk to the judges about DOE. So I go to this training, and this guy gets up first. He's the head of COMET. And he starts talking. He's got this beautiful, slideshow and all this stuff. Sorry, I never have slideshows. And he says, the therapy we use, some of the therapies we use requires, polygraphs. He said, because of course, everybody knows that if you don't admit it yourself, then you're untreatable, okay? If you gotta be the one to admit it. And so he says, so that's why we give polygraphs, to make sure that they can, admit what they've done. And so I'm waiting for a judge to ask a question, and he says, so we make sure to take polygraphs however so often. So I raise my hand, and he says, yes. And I said, what if they really didn't do it? Like that. And he's like, oh, deniers? I said, because they really didn't do it? Maybe? And he says, well, we call them deniers. I said, well, so what do you do with deniers then? Do they still have to go through this treatment? And he actually told me, no, we will go to the judge and tell the judge that you are a denier. And I said, well, can you then ask on the polygraph, did you, commit this offense? And what if it comes back that he's telling the truth? Will you take that to the court so that we can get rid of the conviction? So, no, we can't do that, And I said, and he was totally foolish. They never go to the judge. The only time they go to the judge in this program, I notice, is to ask a judge to impose the program. Because it's completely discretionary with the judges. And do you know now it's almost 90% of them are being sent to the COMET program? more money, more money, more money. And you have to pay for the treatment, which I love, you know? Yeah, it's incredible to me. And so I'm like, you know, I have a client who shouldn't be on the registry because he's a doe. But anyway, I'm fighting that. But he was told that he had to attend 56 or 52 classes, okay, for the entire treatment thing. So he gets his parole gets revoked at one point wrongly. So he's in jail for like 2 months until I can get him out. I get him out. He goes back to start, and they say you got to start all over. And he had already done 26 classes. So I said, he of course comes to me, and I said, no. And so I write the head of the program, Mr. Grover. I said, you cannot make him, start all over again. He's already done. He says, all right, okay, all right. And so when he gets to class 52, they tell him he's got 6 more weeks to go. And he said, no, I don't. I just finished. And the guy says to him, just show up and sign the book. You don't even have to stay. And pay. And pay. And I was just, yeah, they polygraph him. And so, so now I'm all fired up about this, and as if I don't have enough to be fired, as if I'm not always fired up. But, these things just make me so mad. I don't even know how you live your lives. I just have so much respect for you, though. I really do. And your families. I mean, what a horrifying burden it is to never be able to finish a punishment. Is just, I really, tip, if I had it, my hat off to you. So anyhow, that's my litigation and my anger and my rant. But if anybody has any ideas for more, litigation, how I can continue to be a thorn in their side, just let me know. I'd love to do it.
Does anybody bring up the issue of a police state when UPS, the Attorney General, and all these people essentially flip off the Supreme Court and the state when there's specific decisions and orders issued? This is frightening in some respects.
No, I know. No, I mean, that's part of the reason why I sued all of the local folks, too, the police departments that you have to report to. I mean, now let me tell you this, though. A lot of my clients have told me that even the people they report to don't want to do it. It's like, it is such a pain for them to go to your house, make sure you have that no candy sign in Halloween. Do you guys have that? We have that in Maryland.
In Arizona, they come and search everybody's house and they got on the list on Halloween. Make sure you don't have a kid in the closet.
Yeah. Huh? So, yeah, so they have it, and
Do they have the training that they have every Halloween for your people?
what training?
The training where all the sex offenders have to go report to one building?
No, they don't do that in Arizona. They just come to your house.
No.
U.S. Marshals come search your house.
Now, I will say that in Maryland, we have 23 counties in Baltimore City. And in the majority of those counties, the cops are sick of this, and they don't want to have to do this because they don't have the staff to do it. It's a pain, all of that stuff. Now, in maybe 3 or 4, the cops love it. It's like a power trip for them, Oh yeah. And this one, in a very wealthy county in the state of Maryland, Montgomery County, which is near D.C., there's a police officer, a detective there, who, the minute somebody is on the registry in Montgomery County, he will go to the neighborhood wherever you live and put up pink flyers that says, a sex offender lives among you. He'll find, if you're lucky to get a job, he goes to your employer and says, do you know you just hired a sex offender? And he takes just pleasure in doing that. And he can. He's complying with the law. There's nothing in the law that says he can't. It's crazy. Yes, sir. Say again? Yeah. Oh, I don't know about that. I scream a lot. Yes, sir.
I was just going to ask you to speculate a little bit on the future then. So we've got all this done in Maryland. I mean, what other states
No, I think that's a great question. Now, one of the good things, to my knowledge, the clause regarding retrospective restrictions is in no other constitution. But that's not really the point, because I didn't win on that. I didn't lose on it, they just didn't address it. And I know why they didn't, but almost every state has a constitution that prohibits ex post facto laws. I think I heard somebody out in the hall earlier say their state does not, which surprises me, but I don't know every state's constitution. So I always urge lawyers, go to your state constitution, because federal is such an uphill battle. Go look at your own state constitutional amendments, the actual language, because like I said, I didn't know there was this restriction language in our Constitution until I went and actually read it. So I tell lawyers to do that. And which is very exciting to me, is that since the first DOE came out, I've gotten lots of calls from lawyers across the country asking for my briefs and my research because they want to do the same thing. One brave soul from Florida wanted to do it, which is horrible down there. Every place is horrible, but Florida is like, don't they want to have like a leper colony for, I'm not joking, they want to have a place where only sex offenders can live. Really? Yeah, that doesn't surprise me.
In Arizona, it's the law that they have to put those signs on it. When my mom just bought into the house, and when she moved, they went and put a sign on all her neighbors' houses saying, with a picture of my brother, saying that a sex offender just moved into your community. And she had friends in the neighborhood.
Yeah.
And they were talking at the golf course, oh, did you see those signs? And my mom said, that's my house and that's my son.
Yeah. Do they still talk to you?
Yeah.
That's good. That's a good friend. Right. Right.
I've wondered something since I read about this, because I've followed it with a lot of interest. And you've gotten all these very dangerous people off of the sex offender registry. Have sex offenders cited?
No. Do you believe that? It's amazing. No, but that's a great, that's a wonderful, yeah.
We could point to it and say, look, all these people came up and nothing.
Yeah, no, and it hasn't. There's been certainly no major league hit the paper kinds of cases.
Will the legislature push back then?
What do you mean?
The Maryland legislature, will they?
I don't know how much more they can push, to be honest with you. No, it takes the 3/5 of the legislature to put it on a ballot, and then it has to be voted on by the entire state. It's virtually impossible to change the Constitution. Yes, ma'am.
You were talking about treatment law goes, my husband has 63 weeks and he has completed 20 years of probation, 20 years of treatment.
Wow.
You have to do treatment through the whole program before you get that.
Oh, wow. Wow. It is. Yeah.
in the state, and yet when I go to register and I didn't have to do it quarterly, these people are the nicest people always treated me with respect. The other thing was that when we had 3 years ago, we had the conference in Albuquerque, and we had 2 weeks of the worst publicity you ever seen.
Yeah.
Prior to it, we were all you guys were pedophiles who came to go into a dark room
Yeah, right.
and figure out what the schools would go to.
Right.
Which ended up in the long run helping us because I was working registration and we
Mm-hmm.
So I want to kind of see what is going on.
Good. That's good. Yes, sir.
For what it's worth, within about the last year, Rutgers University included a study on fear and what prompts fear in humans. But an interesting sidebar, they did address it about why people are so whenever you see something on the news about sex offender. We had a case in Arkansas just a few days ago about someone who absconded, was found in another state, and was wanted in a third state for raping a minor. But what many people didn't realize, and this was pointed out in the Rutgers study, is that you see these stories, or you hear about them in the media, and they're brought up because the circumstances, the nature of the story, they are reported because they are rare, not typical.
Right, right.
And people don't make
They don't know. They really don't. I know. Yes, sir.
I'm trying to get my arms around the whole ex post facto game a little bit. In dealing with this question of federal versus state, is there something that's fundamentally different about the ex post facto clause in the Maryland Constitution, or did the court in Maryland just disagree with the Supreme Court with regard to whether or not these things are fundamental?
Right. The way it works is the federal amendment gets interpreted by the U.S. Supreme Court, and they interpreted it as not punishment, therefore no ex post facto issue, period. So we already know what the outcome is going to be if you go to federal court, because then all the federal courts have to follow that. And all the states would have to follow that unless they want to grant greater rights to its state citizen, okay? And in Maryland, that's what the court decided. And the only way you can do that is under your own state's constitution, because if they use the federal constitution, they're forced with the U.S. Supreme Court's interpretation, okay? But if you use the state's constitution, the state courts are the only ones that can interpret it. And so that's the difference. That's why I didn't want the feds, because we'd have been stuck with their review of it as not being punishment. And, you know, the Court of Appeals in Maryland could very easily have said, and they do this in a lot of states, we interpret our Constitution the same way the feds interpret the federal Constitution. But this court, thank God, thought no. And I know the reason why is because they really feel that these laws have crossed, you know, over that line where it has just become way too much. And so they wanted some way to be able to rule that way, and the only way they could is under the state's constitution.
But it's not the wording of the Constitution.
No, it's the same, except for that one clause.
It's just a determination that this really is punishment.
Mm-hmm. Yep.
Nancy, if I can interrupt for just
Oh,
a
please,
second.
sure.
This is a shameless advertisement for my session tomorrow.
Oh, good.
In this room at 2:20, I will be talking about that U.S. Supreme Court decision. I'll be talking about the Maryland case and other state cases as well, where they've done similar things, and how we have to overturn the U.S. Supreme Court decision. Okay?
Good luck with that. Listen. You know, I will say this, that some cases have come out of this court as currently constituted with the same justices, like Thibodeau, and there are a couple others that sort of gave me, even though they did not rule in favor of the defendant, the language in some of these cases was such that, for instance, Justice Sotomayor, the female justices, seem to be bothered by these laws. So there is room. I just don't want to be the one to do it. So I've been up there and beaten down a lot, so I'm not interested again. Not for a long time. Yes?
If a person in Maryland is convicted in federal court of a sexual crime, can they be removed from the registry under the...
Yeah, and in fact, one of my class action clients falls in that category. And I have others that were convicted federally that have been removed. If you live in Maryland, of course, you have to live there. Yes, sir.
In Texas, we've been blessed with Richard. Obviously, Maryland has you, California, Janet, and we hear names. I know there's a fellow up in New Hampshire that's been a real advocate. How do we, I'm a registrant, how do I work to get more attorneys involved? And what kind of attorneys? What drives you? What drives Janet? What drives Richard to do these kind of things? And how do we get more attorneys? And what kind of attorney? A defense attorney or a civil rights attorney? How do we get more people involved so that, God forbid, Richard ever get hit by a bus?
Well, you know, actually, and I was talking to, I'm sorry, the gentleman from Ohio that was on the panel, Jeff, you know, after the panel, and, you know, I'm going to give serious thought to trying to form some kind of coalition working group with lawyers and others that want to help, but you know, mainly lawyers that are of the same ilk that want to do this, but just don't know how or what to do. And that was one of the other upshots of the Doe decision. I got so many calls from different states. That's why I was saying Florida, Missouri, somebody in California called me, and, you know, at least light a fire under some people.
I know I will certainly speak for myself.
Yeah. Yeah.
But I'm pretty intelligent.
I'm sure. Yeah.
Mm-hmm.
I know, I was noticing that. Yeah. Well, okay. See, because that's, and I didn't know you were Janice. I was saying earlier I want to meet you. You're, yeah. Oh, okay.
There is a different mindset. So of attorneys who are willing to take these cases, and one of them is you have to not be afraid to lose a case. Okay? And a lot of attorneys don't like to lose cases, and I don't care. So you know, who cares? You know, I don't keep track of my track record. Somebody else might, but it's not me. But the fact is, I do believe in justice, and I believe in protecting the Constitution. And so that's what's most important to me. And somebody else can say, well, you lost that case last week. And it's like, well, who cares? I got another case next week. You know, maybe I'll have that one type of thing. So, but the other thing that I'm finding in California is, wow, we have a lot of attorneys who have now become sex offenders.
Really? Oh, wow.
And guess what? They're now working for me as a paralegal.
Yeah. Right.
And so there are paralegals too in other states, because a lot of states, you can't get a paralegal, you can't be a paralegal and be on the registry at the same time.
Okay. My paralegal is too. Formerly on the registry. I got him off.
Talking about, among other things, setting up or trying to get various law schools to set up clemency clinics. Would that be sort of a model to work from to get this coterie of lawyers?
I don't think so. And the reason is, I think what Governor Ehrlich was talking about is like law school clinics, that you have the students that can do all this legwork for you, because clemency is so it's a huge input of time to get a clemency petition together, and so that students would have that time.
Would it serve as a model?
Well, I'm thinking more of like an association of lawyers and paralegals and really anyone that wants to help, but to be able to spread the word and not have it just in a few states, handful of states here and there.
National Association of Criminal Defense Lawyers.
I belong to them, and yeah.
That'd be great, because when my husband got arrested, I was calling all over the country trying to figure out who was, what to do and talk to.
Right, right. Sure. Yes, ma'am. No, she's done.
How many people are in your class actions?
In my what? Oh, how many lawyers? Did you say? Plaintiffs? I'm sorry. I think I have 12, might be 13. I added another one in a amended complaint. Oh my God. I'm here. You know, like I said, I'm more than willing to help. There you go. Just buy my plane ticket.
I'll buy you a plane ticket.
Okay. And I like to have good food too. And wine. Sorry, I have to have wine. White wine, please. God, I'm sorry.
You may have said it and I missed it. Was Maryland considered to be in compliance with the SORNA or the Adam Walsh Act?
No, they're not. Not now. But in fact, that was one of the state's arguments as to why you can't do this, court, because we're going to lose all these funds from you know, and I, of course, was ready for that and had the numbers of amount of money that was lost, and the judges just didn't care about that. They really didn't care. It was before this case. And now, yeah, they're no longer in compliance. Well, they have no choice, yeah. Because of this decision, yes. Mm-hmm. Yes. Either that, they have a choice. Either give up the money or you figure out a way to be in compliance. But you can't be in compliance with the ex post facto. You just can't. So it is what it is. They're stuck. Right. Gosh, this is 2 years ago. I think it was only something like 20. I don't even remember. I don't want to put a number. It was in my brief, but I can't remember. But it was not insignificant, but it was also nothing that, you know, would make a huge difference. Yes, ma'am.
Our biggest problem as far as sex offender is that Romeo and Juliet law.
We don't have one of those. Well, let me make sure I understand. What is it? Tell me what it is first. Make sure I...
Juliet law that they have, I think they just created, and what it is teenagers that have intercourse with their boyfriend, girlfriend, and their teenagers.
Uh-huh.
But they end up in the same situation as a registered sex offender, go to jail, be in there for 20 years, come back out 40, 50 years old, and still, I have one guy that he was married to this lady. He was about 18 and she was about 16, 17 at the time. And they were married and had children, grandchildren, 41 years ago. And
Oh, I see.
sex offender, and he's still in prison.
Oh, see, I misunderstood then. We call it, in Maryland, we have it strict liability. It's that it doesn't matter. If you fall in that age category, you know, it doesn't matter. Really? I see, when somebody mentioned that Romeo and Juliet, I thought that was a good thing. No, I mean, because I thought it meant, you know, we recognize that young people make stupid mistakes, you know, would kill themselves because they're in love. Okay, go ahead.
Just to be clear, if I committed my crime in early 1983, if we moved to Maryland, seriously,
Come one, come all, you would not be on the registry.
we might lower the IQ of the state.
No. Yes.
What happens a lot is that states have different ages of consent, And so you look at the one hand and you say, okay, this is not rape, not regular rape, possible rape, because the girl was 16 and she could consent. But they come back around because under the definition of child, that person is under the age of 18, and therefore it's a sexual offense against a child, even though you have this other law that says it was consensual. So then you are a sex offender because you have statutory rape.
Right. That's what we do have statutory.
It's child abuse because the child is up into the age of 18.
Okay. Yes, ma'am.
It's not statutory rape, it's secondary rape.
In tier 3?
Yes.
I have two questions about bail. If for the people in person, the people that did qualify already, that are removed from the registry, what happens if they move away from Maryland?
That's a great question. It depends is the answer. It depends if you move to a state that says, no matter what the state you're moving from says, if you're convicted of this crime, then you will have to register here. So you need to look at the law of the state that you're moving to. Uh-huh.
Because I would qualify under if it was here in Texas. When the class action goes through, is there going to be some you have to be here for a certain length of time? Because I can root for the Ravens.
And the Orioles. No. If you're living in the state of Maryland when it's concluded and you come within one of those classes, you're covered.
But if you move after, you do your job and you win.
Right.
And that's in September of 2000, whatever.
Yeah.
If I decide to move in November of that year, would I be able to then say, okay, I qualify, or do I have to be there when you win?
He's subject to whatever state laws he lives.
I'm getting confused. Say it again. I win the class action in September. And you come within one of those...
Because I know you won.
Yeah.
I'm going to pack up my family and move to Maryland 3, 4, 6 months afterwards.
Uh-huh.
Can I then go to you and say, okay, I'm here now, I qualify under Doe, get me off the list?
Yeah. Yeah, it's leaving Maryland. Right. Because once, if I prevail, if I win the class action, what that means is Doe applies to all these people, these classes that I've told you about. So if you come to Maryland and you're one of those people, they can't make you register, is the point. So it's not like you come, you have to register, and then I have to get you off of it.
But when I leave Texas, I have to tell them where I'm going.
Yes.
How do I sell to them? Well, I don't have to register where I'm going.
You don't have to sell it to them. But I will tell you this, because I have a client in that situation who came to Maryland from Texas, and Texas still won't take him off the registry. And so I filed, you have to have a written request or some such thing. I looked at the statute. And then so this guy with this lovely Texas accent called me the other day from the Department of Corrections saying he's going to send me, he said, normally we don't have to take you off the registry in Texas, even if you move to another state, he said, unless under certain restrictions, he said, and he's mailing it to me, so I don't know what they are yet, but it seems foolish and counterproductive to me because you don't have to update your information in Texas. They can't charge you with failing to register. And to me, this, I think there's an argument here somewhere. I can't quite put my finger on it, but since Texas has to provide that information to the feds, they're providing them outdated information, and I don't think the feds would be very happy with that. So I don't see how they can keep you on the registry if you no longer live, work, or go to school here. What was that? but they're still sending it to the FBI.
And knowingly false.
Yeah, yeah. I mean,
Carolina will leave you on the registry forever, but it just says move to Maryland.
Yeah, you move, but they don't take you off.
In Texas,
Same thing, we have people that are dead on our registry, and it will say,
well, that protects the community. Sex offenders.
Search for deceased sex offenders.
Really?
yeah, I guess you go visit them.
Yeah, go.
We have in Florida, you move to another state, you provide them information where you're going. We have certain information that requires registration and updating, like every vehicle that belongs to every person in the household that you live. So whether you drive that car or not, you have to register every vehicle to every person that lives in the house. So now you move out of state, but the other people that you were living with didn't move.
Right.
So that information should come off the registry in Florida. Well, when my son went to Colorado, he had to give them notification that he was leaving the state in 48 hours, he was going to Colorado for interstate compact, yada, yada. And they would not remove any of that vehicle information because he was still going to be in the state for another 48 hours. So that information remained there. So I went to the registry office and I said, it was like, I don't know, 3 or 4 weeks after my son had moved, and I said, I want to update the record for DC number, yada, yada. My vehicles need to be removed. And they said, well, you can't do that. He needs to do that. I said, well, he's in Colorado. And they said, yeah, but this information needs to be updated by the registry in person. I said, but he's in Colorado.
That goes on first.
Right, well, having the chicken or the egg, right? So we go back and forth and back and forth. Ultimately, I got them to remove the information, but here's the really interesting thing to me. I did not have to provide them any ID. I didn't have to show them any information whatsoever on the vehicle. I didn't have to prove to them that my son was in Colorado. I just argued with the guy longer and took all the information off.
Yeah, see?
In Arkansas, you not only have to do it with all the vehicles, but you have to do it with your boats and any aircraft that you own.
Maryland too, yeah.
Yeah, if you live in a mobile home, you have to register the registration number on your mobile home just in case you pick up your house.
And move. Yes.
Is there a conviction date? We're talking about retroactive application. So is there a date, if you're convicted after that point, that you're going to be required to register in Maryland, but if you're convicted before that date, you're not?
Yes, it would be October 1st, 2010.
Is it the conviction date or the date?
The date of the offense. That's critical. It's not when you're convicted. You look, in Maryland, anybody whose offense is committed after October 1st, 2010 can be made to register. And anybody before October 1, 2010 might be subject to the Doe decision. It all depends on lots of different things. Yes?
This is the attorney's email in Oklahoma, and this is the case he won that
Oh, excellent.
some of the registrants off there.
I remember Starkey. Yeah. Oh, good. Wonderful.
So this has been quite a session. I don't think we actually want to end it, but let's take 2 more points or questions that everyone pays attention to so that we stop all the extraneous talk, and then we can thank our speaker, bottom of our hearts. On the registration, you've got people off Maryland registry, radio, no pictures, things like that. What about all these secondary, third level,
I know. Yeah, yeah. The ones that are holding you hostage for money. Yeah. That's one of our plans. Because I wanted to talk to you about how I can do that, get them off of that too. But by the way, you've been successful, right? I thought you had. Somebody called me.
Yeah, well, we got the call, and then the judge reversed herself.
Well, keep trying.
One last question or comment.
No takers?